session on today's date, July 8th, 2026. We have two dockets. We have an announcement docket and a motion to revoke probation docket. When I call your name, please come before the court with your attorney. If your attorney is not here, we'll wait for your attorney to arrive because your attorney may be in another court handling another matter. If you are representing yourself or if you do not have an attorney, when I call your name, please come before the bench by yourself. First case is cause number 26-CCCR-0908. Case is filed in the state of Texas versus Erica Richards.
Your Honor, we're present and we've reached an agreement with the state. We submitted the plea paper to
Okay.
the prosecutor.
Okay, when it's ready, we'll call you back. Okay. Next case is Jasmine Nicole Frazier. It's Moses. Tell her what to put first.
Yeah.
Okay, this is
Yeah.
okay, this is cause number 25-CCCR-1054. Case is filed in the state of Texas versus Jasmine Nicole Frazier. Ms. Frazier, is that your full name?
Yes, sir.
How are you doing, Ms. Frazier? I'm doing fine, thanks for asking. Ms. Frazier, you're represented in your case by your attorney, Attorney Alan Parker. Attorney Parker, how are you doing?
Good, Judge, thanks.
You are. State is represented in this case by Attorney Fred Vernon. Mr. Vernon, how are you doing?
I'm well, Your Honor.
That's good. Now, Mr. Parker, what's your announcement in Ms. Frazier's case?
Your Honor, we're asking for another reset. I've got the video, I haven't reviewed it with my client, and I'm talking to the prosecutor about getting an offer.
Okay,
I think he's gonna give me one today.
okay.
I will, Your Honor.
Give us a standard reset.
August.
Wow.
This case is reset to August 12th, 2026.
I have a vacation letter on that day.
Oh,
I'm sure Ms. Segura knows that.
We don't have that letter.
It's been filed for 2-3 months.
I
I'm just telling you, I get back until the 18th.
okay.
August 4th, thank you.
Okay, let's see. We'll wait.
That's surprising that I actually know it. Only because my wife told me.
The 19th?
Okay,
I should have.
this case will be reset to August 19th. Ms. Frazier, you get your reset from our court coordinator. Once you get your reset, you're free to go. You have a blessed day. Mr. Allen, this is your only case?
This is, that's.
Okay, you're free to go, Mr. Parker, and you have a blessed day. Keona Juba?
Yes. Good morning, Your Honor.
Good morning. Court is in session in cause number 26-CCCR-0574. Case is filed in the state of Texas versus Keona Jubert. Mr. Williams, that's your case. Ms. Jubert, is that your full name? How are you doing, Ms. Jubert? You doing good? That's good. Ms. Jubert, you're represented in your case by your attorney, Joel Vasquez. Attorney Vasquez, how are you doing?
Good, Your Honor. How about you?
I'm doing fine, thanks. Excellent. And state is represented in this case by Attorney Cornelius Williams. Attorney Williams, how are you doing?
Mighty fine today, Your Honor, mighty fine. How are you and your exceptional staff?
We're doing great. Thanks for asking.
You're welcome.
And Mr. Vasquez, what is your announcement in Ms. Jubert's case?
Your Honor, Ms. Hubert is gonna sign our pretrial diversion contract the first Thursday in August.
Okay, okay, let's set we set them for like August the 10th?
Yeah.
Now, Ms. Jubert, your case is reset in his court for August the 10th. Your attorney has informed the court that you will be signing your pretrial diversion contract. I think that's August the 4th.
I think the sixth.
6th? Okay, now, if you sign that contract, then you will not have to appear here on the 10th. But if you do not sign the contract, you need to appear here on the 10th. Do you understand? And the reason why you will not have to appear is because once you sign the contract, your case will be coming in. All right?
Yes.
So, Ms. Jubert, you can get your reset from our court coordinator. Once you get your reset, you'll be free to go. Stay in contact with your attorney and your bondsman, and you have a blessed day.
Thank you, Your Honor.
Always nice to see you, Mr.
Thank you,
Vasquez.
Mr. Williams. You as well. Thank you, Judge.
You are.
To be honest.
Oh, she just.
Thank you very much.
Daniel Corbett.
Yes, sir.
Where's the probation office?
Just step back, Judge.
He's talking.
Because we're gonna need to get the probation.
You need them?
Yeah.
And I spoke with the state judge. We're gonna be requesting a reset because I'm waiting to see what they're doing in Orange County. Maybe to run them CC together.
Daniel Corbett on page 3 of the
NTRP.
NTRP docket. Okay, Mr. Quibido, your full name is Daniel Douglas Quibido?
Yes, sir.
How you doing, Mr. Quibido?
Pretty good. And yourself, Judge?
I'm doing fine, thanks for asking. Mr. Quibido, you're represented in your case by your attorney, Brendan Mitchell. Mr. Mitchell, how are you doing?
Doing great, Judge. How you doing this morning?
I'm doing fine, thanks for asking. State is represented in this case by Attorney Farrah Nixon. Ms. Nixon, how are you doing?
I'm fine, Your Honor.
Okay. Where's Mosby? Okay, and the state is also represented in this case by Attorney Fred Vernon. Mr. Vernon, how are you doing?
I'm well, Your Honor.
That's good. The probation office is represented in this case by Mr. Gary Gilliam. Mr. Gilliam, how are you doing?
Very well. Thank you, sir.
That's good. Now, Ms. Nixon, what's the state's position in Mr. Quibido's case?
We're waiting on to see what he has some DWIs out of Orange County, so we were gonna wait on to.
I say he has a misdemeanor case or?
Yes, Judge.
Is a case in Orange County?
Yes, sir. It's 2 misdemeanors out of Orange County. We're waiting to get that discovery so we can see what we're gonna do in that case. We would graciously ask the court to give us a 60-day reset to give us plenty of time to get that discovered.
Do y'all have a court date in Orange County?
We do not, Judge. I'm talking with the prosecution. I got hired on those cases yesterday.
Oh, okay,
And so I'm trying to expedite that process.
okay. Give us a 60-day reset.
Sure. Yeah. I think you want to. One more.
Oh, okay,
One more. I just want to make sure.
okay.
Here, make sure I'm not saying something. That's what we said when I still. That's what probation says. This, you just confirm it.
And I let,
Okay, because I know we were.
Court is in session and calls number 26 CCCR 0974. Case is style of state of Texas versus David Garcia. Mr. Garcia, is that your full name?
Yes,
How are you doing, Mr. Garcia?
doing well.
That's good, Mr. Garcia. Your case is set on the court's announcement docket. And I think you were here last month.
Yes.
And you signed a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And in that document, you stated that you wanted your case reset to hire your own attorney. Have you hired your attorney?
No, sir, they delayed payment on one of my jobs. So I'm waiting. They told me they will pay me in about 2 weeks.
Okay, have you talked to an attorney?
Yes,
Okay, so you're planning on hiring the attorney that you talked to?
yes, sir.
Okay, so how much time do you need?
At least 2 to 3 weeks for that. payment.
Okay, 2 to 3 weeks. Okay, I'm gonna give you a month.
Okay,
Okay, so this is Mr. Garcia on page 9 of the announcement docket. His case will be reset to hire an attorney. Mr. Garcia, you'll get your reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day.
thank you.
You're welcome. And you said Mr. Van Child is filling out the document? Okay. Okay, the lawyers are. They already talked.
Good morning, Judge. This is Dustin Galmore.
Okay, Mr. Galmore,
I do have two announcements.
okay, hold on a minute. Okay, court is in session and calls number 26 CCCR 0982, case of style of the state of Texas versus Derek Todd Landor. Derek Todd Landor Jr., Mr. Landor is appearing via Zoom. Mr. Landor, you have something on your head? You have to take your mic off of mute. Yeah, get it. Okay, Mr. Landor, you take your mic off of mute. Okay.
Sorry about
Okay.
that, Judge.
Okay, Mr. Landor, how are you doing?
I'm doing just fine this morning. How about yourself?
I'm doing fine. Thanks for asking. Mr. Landor, you're represented in your case by your attorney, Attorney Dustin Galmore. Attorney Galmore, how are you doing?
I'm great today, Judge. How are you?
I'm doing fine. Thanks for asking. And Mr. Galmore, what is your announcement in Mr. Landor's case?
Your Honor, we're still working on this one. If we could have another announcement date.
Okay, I see, this is a fairly new case. Have you, received your discovery?
Believe we received the written discovery. Your Honor, I cannot tell you if we've received the media. That's process that's kind of in the back door, but I know it's being worked on if it hasn't received it yet.
Okay, what about an offer from the state?
No, I do not know until I've watched the videos. I don't even always look to see if they've made an offer, to be honest with you.
Okay, we're gonna give you a standard reset. Okay, this case will be reset to August 12th, 2026. Mr. Landor, your case is reset to August 12th, 2026 at 9 a.m. in County Court at Law Number 2, Jefferson County, Texas. On that day, you need to be in court in person. Do you understand?
Yes, sir.
Okay, stay in contact with your attorney and your bondsman. You're free to go and you have a blessed day.
You too. Thank you.
Okay, next case is cause number 26CCCR 0886. Case is styled the state of Texas versus Trent Ryan Lee. Mr. Lee, would you please come forward?
Yeah.
Stand in front of the bench. Mr. Lee, how are you doing?
Good.
That's good. Now, Mr. Lee, you're represented in your case by your attorney, Attorney Dustin Galmore, who is appearing via Zoom. And Mr. Galmore, what is your announcement in Mr. Lee's case?
Your Honor, we are still working on this one too. I believe this one we do not have the videos, and we're trying to get that resolved.
Okay, so you do not have the video and you're trying to get it resolved?
Yes.
Okay, so we'll give you a reset now. Is August 12th a good date, the same date we set the last case?
That should be sufficient. Yes, Judge. Thank
Okay,
you.
this case will be reset to August 12th, 2026 at 9 a.m. Mr. Lee, you'll get your reset from our court coordinator. Once you get your reset, you'll be free to go. And you have a blessed day. Stay in contact with your attorney and your boss.
So thank you.
All right, stand in front of the court.
Have a good day, Dustin.
Thank you. Y'all
And
too.
Mr. Galmore, you're free to go as well, and you have a blessed day.
Thank you. Appreciate it, Judge.
Okay. up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Ms. Richards, before you signed and initialed these documents, did your attorney go over all of these documents with you?
Yes, sir.
And did you understand everything that he went over?
Yes, sir.
Is everything in these documents true and correct
Yes,
to the best of your knowledge?
Yes, sir.
Ms. Richards, are you a citizen of the United States?
Yes, sir.
State came to this honorable court, State's Exhibit number 1.
No objection.
No objection. State's exhibit number 1 will be admitted. And Mr. Faggett, you've advised and counseled Ms. Richards. Is there any evidence that she is currently mentally incompetent to stand trial?
Absolutely none, Your Honor.
Ms. Richards, your attorney, Mr. Faggett, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Richards, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The essential terms of the agreement is as follows, Your Honor. It'll be 3 days in the Jefferson County Jail, time served, time actually served, and our court costs will be taxed and retired. Is that correct, Mr. Fair?
That's correct.
Okay, Ms. Richards, the state is offering that you serve 3 days in Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail because you have already served 3 days in Jefferson County Jail.
Yes, sir.
Therefore, you'll be given credit for the time that you have already served.
Yes, sir.
The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Richards, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Ms. Richards, I'll follow the plea bargain agreement that you had entered into with the state. Now, Ms. Richards, you'll,
Yeah.
the paperwork needs to be completed. You'll have a seat. Now, before you have a seat, I noticed that when I was saying what the punishment was, you must have thought you was going to jail because you looked a little worried. And then you was relieved when I told you that you've already served your jail time.
I keep forgetting that I already sat in jail for it.
Yeah, okay. Well, you will be all right, but once you sign your paperwork, you'll be free to go. And you have a blessed day.
Wait on.
All right. Just have a seat in that first challenge walk.
My
And yes, you may be excused and you have a blessed day.
Thank you, ladies.
Okay, Mr. Paget, okay.
Got the court split on you. Did you say I could approach, Your Honor?
Yes,
Okay. Thank you.
okay, you have a Tawana
Yeah,
Leger?
we need to approach on a motion on that as well, just a version.
Tawana Leger?
Yes, Your Honor.
Is Tawana Leger?
It is.
Where's Tawana Leger?
Miss Legend?
Oh, she has a case in felony court.
She has.
We have to wait for her to come over here. She
Is
she
over
checked
there
in.
now? Okay,
Yeah.
I don't know. Okay.
She
Oh, I
checked
did
in.
not know that.
Yeah.
That's fine. Well,
Okay, now you have Miguel, yeah, Miguel Lorenzi Jr.
Yes,
He's appearing on Zoom.
he's on Zoom, but
Mr. Lorenzi, how are you doing?
this is.
I'm doing fine, Your Honor. How about yourself?
I'm doing fine, thanks for asking.
Yes,
Now,
sir.
Mr. Lorenzi, you're represented in your case by your attorney, James Paget, who's present in court. And Mr. Paget, how are you doing?
Doing well. Good morning, Your Honor.
Good morning. Mr. Paget, what is your announcement in Mr. Lorenzi's case?
Your Honor, I've spoke to the prosecutor as well as the probation officer. Here's the situation. Mr. Lorenzi, Your Honor, has a new DWI and it's set for 8/11.
In this court?
This isn't the probation.
Yes, Judge, just coming in.
It's set for 8/11, Your Honor. So
Could you, well, I
Yes,
need to
that-
get that cause number.
I got it right here, Judge.
Okay,
Mr. Lorenzi, I've discussed this situation with him and he is going to hire me this afternoon.
okay,
So this afternoon, I will file a letter of representation, request discovery, and I'll be, prepared to move forward. We have a
It
reckless
is.
driving here, Your Honor.
okay.
It's
Was-
26 CCCR 1688. 26 CCR 1688.
Okay. And this is
And it's an
BWI.
announcement or initial appearance on August
That is
11th.
correct.
We need to set
We need
both of
to,
these cases on the same day.
And I'll file the letter. I'm sure that it will be, I'm sure that might be, I don't know if it's a Tuesday or a Wednesday on that initial appearance.
Cool.
But I'll have my letter filed. You know, if he hires me this evening, I'll have it filed by tomorrow. I assure you of that.
Okay, let's,
And I'll request discovery before the week's over.
okay, let's do this. If
We'll fast track it. I'll move quickly.
we're gonna reset that, that is set for August. Well, that's, we could set this on August 12th.
Whatever pleases the court.
Yeah,
I mean, I don't know if I'm going to have the discovery all done by then, but whatever pleases the court.
yeah, because I mean, we was gonna reset this other one, Miguel Lorenzi.
You know, I'll roll with it. We'll do what we need.
Yeah, but we'll put both of them on the same day.
We'll do what we need to do, and I'll let Mr. Williams know if I've received discovery by that time and reviewed it. And I'll request an offer. So he knows I'll email him when I receive it.
Okay, now, Miss,
It's my docket too. I need
Who you
to
doing?
do. We can.
yeah, we're gonna have both of them on August 12th. Okay, Mr. Lorenzi,
It works.
both of your cases will be reset to August 12th.
Okay.
August, I thought it was August 11th.
Well, the 11th was the initial setting.
But the announcement day.
That's what.
Oh, so you
that's what I was
voted to the
gonna say.
12th.
So that
I
would be
understand now.
Tuesday would be
Okay,
that
okay.
initial appearance for arraignment or initial appearance. So I
Right,
understand.
yeah,
Makes
we'll-
perfect sense to me.
Yeah.
August 12th, okay, I understand.
Okay, we'll move both of these cases to August 12th. Mr. Lorenzi, stay in contact with your attorney
Yes, sir.
and your bondsman. They will be given notice of your reset date. You're free to go. And you
Yes, sir.
have a blessed day.
You have a blessed day also, Your Honor.
All right, thank you.
Thank you.
Okay, Brian Tyson,
Yes, we have.
What y'all got on
Are
Tyson?
you ready on that?
No.
Mr. Tyson?
Oh,
That's a police.
okay, we'll call you back up. I'm gonna hold on
Sent it,
that.
right? I think I sent it.
Oh,
I
okay.
have 2 seconds, Chairman. I'd give her a whole 30 seconds if it pleases you. What are you giving? That smile on your face. Mr. Tyson, you come forward. I know.
Which one are you playing on?
We are pleading on
5-8?
0058, Your Honor, 26 CCCR 0058.
That's correct.
This is the 1245 on the 2 other cases that I explained to you, so I need you to sign right there. And then let's Holmes and make sure you look in line to see. You get that opportunity. There's no legal reason for that. Other than.
Mr. Coordinator,
Yes, ma'am.
can that release the
So at least.
You can read, oh, the person's name,
So, let's just make sure. You look.
That's right. That's what I thought.
So.
yeah, Bianca Joseph.
Thank you, very
I apologize. That's the computer. I tried to write a little neat and it
Yeah.
kinda blurs over some of the stuff.
Okay.
Excuse me. If you want to tell him, read.
Okay, Jefferson County Code at Law. Number 2 is back in session.
That's how you do it.
Court is in session in 3 cases. Cause numbers 26 CCCR 0022. And cause number 26 CCCR 0024. Hey, Miss Mosby. Miss Mosby, kids. Okay. Next case, the last case is cause number 26 CCCR 0058. All 3 cases are styled the state of Texas versus Brian J. Tyson. Mr. Tyson, is that your full name?
Yes, sir.
Mr. Tyson, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Tyson, you may put your hand down. How are you doing, Mr. Tyson?
I'm doing fine.
That's good, Mr. Tyson. You represented in your case by your attorney, Attorney James Paget. And Mr. Paget, do you waive a record in Mr. Tyson's case?
We do, Your Honor.
Mr. Tyson,
Sir.
in cause number 26 CCCR 0058, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Brian J. Tyson, on or about November 18th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense, violation of bond or protective order. Mr. Tyson, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Tyson, how do you plead? Guilty, not guilty, or no contest?
Contest.
Now, you're pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Is that true?
That's what no contest means. Now, Mr. Tyson, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked no contendere, which means no contest. The initials are BT. Do you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature on the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Tyson, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Tyson, are you a citizen of the United States?
Yes, sir.
State tender to this honorable court, State's Exhibit Number 1.
No objections to state's number 1, Your
No
Honor?
objection. State's Exhibit Number 1 will be admitted. And Mr. Paget, you've advised and counseled Mr. Tyson. Is there any evidence that he is currently mentally incompetent to stand trial?
None at all, Your Honor.
And Mr. Tyson, your attorney, Mr. Paget, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Tyson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond
Mr. Pat.
a reasonable doubt.
Yes, sir. I didn't. Is it the battles in the mutual, said on it, agreed? If not, then I'm about to ask it. I don't know what we wrote.
Well, it's not, but
I
I
don't
mean,
even know what we wrote.
if it's a requirement, then he'll do whatever he needs to do to complete the terms and conditions.
Oh.
On 5-6.
Okay,
On the agreement, what's the batter's intervention program?
no. No, he wants to know whether there's on the
That have to
agreement.
change those.
You could, if y'all need to see it, it's not
Yeah,
on here.
That's still acceptable.
Yeah, it's the batters and intervention program is a condition of probation on information protected by the public.
You're
We
gonna have to-
understand it
you're
and we're
gonna
not opposed to it, Your Honor.
You're gonna have to change.
Thank you. I apologize.
It's okay. I mean, it
When
is,
when I looked at it,
it's okay. It wasn't on there, but it is definitely a standard, it is definitely a standard condition, okay? And if it wasn't, that's the only physical thing that we're not supposed to do. I say physical things, the only thing you're going to do other than payment. Yeah. Because I'm giving you this, you're utility and motivation. About this program, I told you about.
It'll be built.
This, you telling this.
Yeah.
I will initially.
That is intervention prevention program.
I explained this, it was just not. Just put your initial. I apologize for that.
Yes, I mean, when I looked over it.
Read it. There.
Okay.
Those are the ones you-
Thank you.
You might forget it, and if you don't do it, they'll sign you. But do it, you're gonna be out there.
Okay, now, Mr. Tyson, are you satisfied with the services of your attorney?
Yes, sir.
And Mr. Paget, is there any evidence that your client is currently mentally incompetent? Say?
None, Your Honor.
Okay, state, do we have a plea bargaining agreement in this case?
We do, Your Honor.
And what is that agreement?
The essential terms are as follows, Your Honor. In consideration for pleading on the violation of the order of protection, the state recommends that 180 days in the Jefferson County Jail, they'll be probated for an 18-month period of time. There'll be a $100 fine, Your Honor, 60 hours of community service, and attending, completing the batter's intervention program, and no contact with the victim in the case, Ms. Bianca Joseph. In consideration of the plea, the state will dispose of the remaining two matters, 26 CCCR 0022, the resisting arrest, and 26 CCCR 0024, evading detention and arrest by section 12.45 of the code of the Texas Penal Code. Is that correct, Mr. Pat?
That is your understanding, Your Honor. But you'll.
How much is the court cost? 287.
We reduced it, given that doesn't include probation, so you want it, we know the fees. So I
Let's
said,
do the same, you'll release $4,500, maybe a little more. So he's not trying to get in your pocket, he just don't want to see you back. But you're right on that, no.
no,
Put your foot in his arms. You must.
before your time. Roberto Duran. Roberto Duran, Sugar Ray Leonard.
You say this.
Well, yeah, but see, and we even come back here in Beaumont, people don't realize. People don't realize
Bubba
what the shame he
Lashane,
brought.
Bubba
Brought the number
Lashane.
one contender. And some people.
Wilford Scipion.
Alexis Guerrero.
It was Alexis Guerrero. All of the judges on top. It was Guerrero. It was. They boxed in the Civic Center. didn't they?
Mhm. Okay,
Nobody's thinking.
Mr. Tyson, the state is offering that you serve 180 days in the Jefferson County Jail, but you will not have to serve 180 days in Jefferson County Jail because you'll be on probation for a period of 18 months. During the 18-month probationary period, you'll be required to pay a fine of $100 plus court costs of $287. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $103 a month. Will you be able to pay the $103 each month?
Yes, sir.
You also be required to perform 60 hours of community service, attend and complete a batter's intervention and prevention program, commonly referred to as BIP. You cannot have any contact with the complaining witness in this case, Bianca Joseph, and you will be required to adhere to the other standard terms and conditions of this probation. Now, the state will be dismissing cause numbers 26 CCCR 0022, cause number 26 CCCR 0024 by way of a 12.45 of the Texas Penal Code. Now, Mr. Tyson, do you understand the state's offer?
Yes, sir.
You think the state's offers in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Tyson, I'll follow the plea bargain agreement that you have entered into the state. Now, Mr. Tyson, before you go over to the bailiff to finish the paperwork, I need to hand you a document that I need to go over with you. Okay, this document is titled Model Written Admonition on Ineligibility to Possess a Firearm Ammunition. And it states that in accordance with the Texas Administrative Code, Section 176.1, the court hereby admonishes you of the following. Number one, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code, Section 46.013, firearms mean any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have, as an integral part, a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. For more information about the laws that make you ineligible to possess a firearm ammunition, or for more information on how long your ineligibility to possess a firearm ammunition lasts, the court recommends you contact an attorney. For your reference, you may wish to consult the statutes listed below, which may or may not apply to your circumstances. Code of Criminal Procedure, Article 17.292, Magistrate's Order for Emergency Protection. Code of Criminal Procedure, Article 27.14E1, plea of guilty or nolo contendere in a misdemeanor case. Code of Criminal Procedure, Article 42.0131, notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, unlawful carrying weapons. Penal Code Section 46.04, unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective orders. Now, Mr. Tyson, the written admonition that I just read to you and that you have before you is for your records. You can stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day. All right, thank you.
I have Mr. Ramiro Rodriguez Jr. on.
Okay.
The MTRP doc.
Okay, I need to sign this. He gotta get printed on this.
Now, Jared, sorry.
Okay.
Ramiro Rodriguez Jr., Your Honor. MTRP doc.
MTRP.
Oh, Ramiro Rodriguez Jr. Okay, this is cause number 25 CCCR 0014, case of style of state of Texas versus Ramiro Rodriguez Jr. Mr. Rodriguez, is that your full name?
Yes, sir.
How you doing, Mr. Rodriguez?
Doing good. How about yourself?
I'm doing fine, thanks for asking, Mr. Rodriguez. You're represented in your case by your attorney, James Paget. Mr. Paget, what is your announcement? And Mr. Rodriguez, state, do y'all have an agreement?
Yes, Judge, we think that He's current, just about current on his fees. He current on, the community service. There are two new offenses. He's to terminate in October. Those two new cases have not been filed within our office. Having said all of the preceding, Judge, we're going to ask that this matter be by agreement set to September.
That is our understanding, Your Honor. My understanding is my client is current. He'll owe 125 before the month's up. He total what he owes is $452. Everything else the way I understand it has been done. So my understanding is we're gonna let the two new cases fall on their own merits.
I need to see if they're
Okay.
coming in. That's what I want to see. If they're not in like by September, we'll revisit in September, Judge. If we can
Okay, now
continue,
what are the offenses, two new offenses?
DWI and possession of a firearm.
I'm not familiar with.
Okay,
But
DWI.
two, I mean, he's checked and I checked.
Yeah,
before.
but then DWIs take a long time.
Yeah.
Sometimes, sometimes there could be 8 months to a
That's
year.
why I could wait till September. We can see in September, then I can know how.
Yeah,
we'll
because it
proceed.
was a blood test. If it was a blood test, we could get this thing done quick.
But it's gonna be a while.
Well,
Yeah.
and again, I assure you, Your Honor, that I'm prepared to move forward.
So let me ask you
Soon
this,
as-
so if it's not in by, so let's say they
Sure.
haven't filed. Now, if it's two cases, if they occurred on out of the same criminal
They did.
episode,
They did.
sometimes, as well as you know, sometimes the arresting agency file the case that is not a DWI first, and then that DWI is still out there hanging.
Well,
So,
and
yeah.
I'll,
If that's like, I'll say this, if that's the case, Judge, I'd like to just see if we complete everything probably by September, and if he terminates in October, Judge, then we'll probably
Okay.
withdraw the motion to revocate probation on this,
Okay.
let those other cases rise.
Okay.
and I will tell you, based on my experience, I had a felony DWI in the 252nd, same scenario. And the court actually made the phone call to the state to try to get the test moved up, and it was still almost 2 months before, and that's where the court
Yeah,
taken.
but it's like that all over the state.
It is, so,
It's,
I'm,
okay, so what we'll do, we're resetting them a September date,
That's fine.
okay.
and then we'll do
Middle
the
to end
best
of
as we can.
September would be fine.
We'll be ready to roll. I mean, I'll be prepared to fast track whatever we need to do.
That correct, Mr. Gill?
Yes, sir.
That's the best option.
Okay,
And that was also the probation officer's recommendation as well, Your Honors.
okay, give us a reset date. Okay, Mr. Rodriguez, this case is reset to September 16th, 2026. You can get your reset from our court coordinator. Once you get your reset, you're free to go. And you have a blessed day. And
Thank
Mr.
you.
Paget,
Well,
that's that we still wait on, let's
No,
see if
but
she's
she's
turned
here.
around.
Relax.
Tawana or Leger?
Mr. Berman. When I do not see Mr. Berman. in the court, do y'all know what's present? Can you step out?
This is Leger.
What y'all doing?
I think you know, she goes again for that problem. I'm not going to discuss the fact.
Okay, this is cause number 25 CCCR 1720, case of style of the state of Texas versus Tawana Leger. Ms. Leger, is that your full name?
Yes,
How are you doing?
I'm all right yourself.
I'm doing fine, thanks for asking, Ms. Leger. You're representing the case by your attorney, Attorney James Paget. And Mr. Paget, we also have before us Attorney Samuel Masradian. He's Assistant Criminal District Attorney. Attorney Masradian, how are you doing?
Doing well, Judge. Thank you.
That's good. Now, Mr. Paget, I have before me a motion to revoke as counsel in Ms. Leger's case. Okay, now, Ms. Lejay, have you received a copy of this motion?
No, I haven't.
Do we, print her off a copy so she can review?
If I may, Your Honor, we, had reset the case. This is the third time that we come before you, where you have reset the case 30 days or more for her to contact me. I've had discovery now for 3 months, 3 to 4 months. Prepared to discuss it with her, ready in my office. You have
Just
reset
print
it. You have reset it. This
Okay, do
is the
that.
third
Okay.
time for her to, get with me, and us review discovery. So I did not follow the motion lightly. I didn't, I waited as long as I possibly could to do so, and it's not something that I want to do or I take lightly. Thank you. Yeah. Your pen. Thank you. Strong. No. Good. Here.
Okay, could you hand this document to Ms. Lejay so she can review it? Have you reviewed it?
Yes.
Okay, now, do you have any objections to Mr. Paget withdrawing as counsel in this case?
No.
Okay, now, Mr. Paget, the court is going to sign the order granting you permission to withdraw as counsel. You're relieved of your duties and responsibilities and obligations in this case.
Thank you.
All right, you're free to go and you have a blessed day.
I appreciate it. You can just let you.
Okay, now, Ms. Lejay, we need to give her a clipboard.
Thank you, Your Honor. May I be excused?
Yes, you may.
Thank you.
You have a blessed day.
Yes, sir.
Yeah, just hold on.
You do as well. Thank you, Mr. Patton.
Okay, Ms. Lejay, the bailiff is in your clipboard and has some documents on the clipboard. First document is titled, Judge's Explanation of Rights to Defendants Without Attorney. Now, that document basically states that as a defendant in a criminal case, you have 3 options. 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. And number 2, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Now, number 1 states that the first paragraph below number 3 actually states that if you want an attorney and you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. The second one-sentence paragraph states that if you want an attorney but do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire. The financial questionnaire is a 3-page document that is also on that clipboard. The document is titled Jefferson County Affidavit of Indigence. You would have to, if you would like to apply for a court-appointed attorney, you will fill out the entire first page of that document, and then on the second page, you'll fill out the top portion that is titled Defendant's Oath, and then the middle portion that is titled Unsworn Declaration by Defendant. Now, the third one-sentence paragraph is for individuals who will be representing themselves. That is, they'll be waiving the right to an attorney or giving up the right to have an attorney, and they'll be representing themselves. And if you represent yourself, actually, you'll be your own attorney. And so just like your attorney can negotiate a settlement with the district attorney's office, you can do the same because you're representing yourself. Now, that third one-sentence paragraph states that you may not speak to the prosecutor unless you first sign a waiver of your right to have an attorney. Now, the waiver is another 1-page document that is also included on the clipboard, and it is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You'd have to read that document, sign it and date it, and then you'll be allowed to talk to the prosecutors. Now, the next paragraph in block form is for individuals who will be representing themselves. It states that be aware that the dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you are representing yourself, the last one sentence paragraph states that you may change your mind at any point and request that an attorney be appointed to represent you. Now, at the bottom of that document in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you'll place your initials on the first line to the left. If your choice is to, if you've already been appointed a court appointed, well, if your choice is to ask for a court appointed attorney, then you'll place your initials on the third line to the left. Now, if your choice is to represent yourself, you'll place your initials on the fifth line to the left. Now, once you have finished initialing one of those lines, then you assign your name on the line that is titled defendant, and you would date it today's date.
Yes,
Okay, do you understand?
yes, sir.
Okay, you can go ahead on and make your choice and then give the document to the bailiff and she'll hand it to me. Okay, now, you can take a seat. I see here you want to apply for court appointed attorney. You can take a seat and fill out that Jefferson County affidavit of images. You know, as I mentioned to you earlier, you're gonna fill out the entire first page. You'll turn to the second page, fill out the top portion that is titled Defendant's Oath, and then the middle portion that is titled Unsworn Declaration by a Defendant, and then you'll stop. Let the bailiff know that you're finished, and then we'll call you back up.
Yes, sir. Thank you.
Okay? This. Anybody ready to go on? This is dismissal. Is that person here? Yeah. Juan Figueroa? Okay, that person. I'm just doing a dismissal on Juan Figueroa. What was that?
Your old over in felony court
Okay,
sale.
okay. I just dismissed this. Maybe you working on it? Did that part, did that? Miss Mosby, did, Taylor Neville show up? Taylor Monet Neville, that's her?
Neville?
Oh, I didn't know
Yeah.
she had a
that's the
plea.
one I'm working on.
Oh, I didn't know.
Yeah.
There's nothing up here. Okay, just have a seat.
And the other one that checked in earlier, Ms. Provost's line, she's,
Who is that?
what's her name? She's on side. Yeah, she.
Oh,
No.
no.
She's just cleaning.
Kessler's. Okay, Aubrey Anna Kesterson, that's the person?
Yeah, she's on side.
Okay, you can have her come in.
They have a fun sit outside when we call them.
Yeah. Is that her?
Yes. Yeah.
Kesterson, would you please come forward? Come forward. Okay, this is cause number 26CCCR 0830. Case is style the state of Texas versus Aubrey Anna Kesterson. Ms. Kesterson, is that your full name? How are you doing, Ms. Kesterson?
Not that great. My dad just passed away.
I'm sorry to hear that. You have my condolences, you and your family. Ms. Kesterson, you're represented in your case by your attorney, Margaret Provo. And Ms. Provo, how are you doing?
Doing fine, y'all.
That's good. State is represented in this case by Attorney Farrah Nixon. And Ms. Nixon, how are you doing?
I'm fine now.
Ms. Provo, what's your announcement in Ms. Kesterson's case?
Your Honor, we would like to have another 30-day extension on 30 days. I just got the assignment of praise less than 30 days. And also she just got sentenced in her.
I just went to felony for first.
And what happened on that case?
Uh, they gave me 8 years deferred adjudicated probation, with the $500 penalty fine for that I have to pay throughout the.
Okay. Do you know whether or not this case is, was disposed of through the felony case? Do we know? Did anybody talk to the felony attorney?
There, well, I know that there was, it's the theft charge or that,
On the third charge.
I know it was a theft.
I know,
I
what I'm asking, did anybody talk to the felony attorney to
I'll
see
look
if they disposed of this case through the felony case?
No, Your Honor.
No, we haven't yet.
Okay,
No.
well, we might need to look into that before we do anything right now. Okay? Yeah,
Okay.
okay, it's just gonna, just have a seat, it's gonna take a couple of minutes for them to find out that information.
I have another. case.
Okay, yes, sir. You have Charles Edward Allen
Yes.
Jr. Okay, Charles Edward Allen is appearing via Zoom. Mr. Allen? I see his thing on Zoom. You can take your mic off of mute. You might have to, you might have to log out and then log back in.
Yes, sir. Can you hear me, sir?
Yes,
Your Honor?
yes, I can hear you. Okay,
Okay,
now,
thank you.
Mr. Allen,
Yes, sir.
how are you doing?
Pretty good, sir.
Okay, that's good. Now, Mr. Allen, I have a note here that said that you're supposed to appear in person today. Why are you not here?
Miss Provo told me I could meet over Zoom. I didn't know I had to be in person. I'm sorry.
So I did tell him.
I didn't
Okay.
know. I would have been there.
Okay, because this is an old case now. Okay. Okay, this case was transferred from County Court at Law number 3. 658 days. Okay, so Miss Provo, did you get your discovery in this case?
Yes, Your Honor, I did complete my discovery, and received the video the other day. I just got off of this morning, so I need time to discuss with him, about this case for another setting.
Okay, we're gonna reset it, we're gonna put it on a pretrial conference docket. Because a lot of times when these cases are transferred from County Court at Law number 3, they're already on the trial docket. So we just put it on an announcement and we start the process all over. So we're gonna put this on a pretrial conference docket. Standard 30 days.
It'll be August 20th.
Okay, this case will be reset August 10th. Now, Mr. Allen, you need to be here in person.
Yes, sir. I hear you. No problem, sir.
Okay. Okay, this case is August 10th, 2026 at 9 a.m. in County Court at Law number 2 of Jefferson County, Texas.
Yes, sir.
Your attorney and your bondsman will be given notice of your reset date. Stay in contact with your attorney and your bondsman. You're free to go, and you have a blessed day.
Thank you, sir.
Okay. Okay, you can
I have,
look into that matter with Kesterson,
okay, I have one.
who is on the MTRP docket. Crystalline Bolton, and she was. Okay, we have, let's see, 3 cases. Cause number M324824. Cause number 25 CCCR 2855. And cause number 26 CCCR 0181. All 3 cases are styled as state of Texas versus Crystalline Rashawn Bolton. Ms. Bolton, is that your full name?
Yes, sir.
How are you doing, Ms. Bolton? I'm doing fine, thanks for asking. Now, Ms. Bolton, you're representing your cases by your attorney Marva Provo. Ms. Provo. Let's see, we have the MTRP. And we have 2 new cases. Okay. And Ms. Provo, what's your announcement?
We would like to set this right early on.
Okay. Give us, I'm gonna set it for contested hearing.
Yes, ma'am.
Right. Give us a hearing date. We can get a deal within 20 days. No less than 20. We'll put it on a Thursday or Friday.
It could be, August 6th or August 7th. It's a Thursday or Friday.
Okay. Will we have anything else on the 6th? On any one of those
We
days?
do have we have a hearing at 1:30.
What kind of hearing? Is it a MTRP?
Look like it's a bench trial.
Okay, so we're gonna put this on the 7th. Okay,
7th, well,
Yeah.
what kind
I'll
of-
be with.
this is a motion to revoke probation here. Contested hearing. Okay, Ms. Bolton,
Yes, sir.
you get your cases reset where there's only one case that's an MTRP.
Yeah.
Which is the M 324-824. That case is reset for a contested hearing. What time?
We have the docket that day, so you want to go that one.
1 o'clock. This is gonna be set at 1 o'clock.
On the second.
Yes,
Okay, yes, sir.
okay,
Yes, sir.
all right. You get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day.
Yes, sir. And may I be excused?
Yes. Yeah, you, subject to, I guess they get information on Kesterson.
Yes. Thank you.
Michael Wynn Van Chow. Van Chow. Mr. Van Chow, your full name is Michael Wynn Van Chow?
Yes.
Van Chow, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing?
Good.
It's good. Now, Ms. Van Chow, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Okay, Mr. Van Chow, your case is gonna be reset to give you opportunity to hire your own attorney. You get your reset. Once you get your reset, you're free to go and you have a blessed day. Is that does he have another case? What's the other case?
He has an
Oh, yes,
Is it on the same day?
It's on the.
Yeah.
Why is,
His attorney is on vacation, you should request it. He said, he has an attorney.
okay, okay, you want a different on this, but put them on the same day.
oh, is that Jennifer Tate Thompson, correct?
It's on when?
Yeah. Yeah.
The 22nd. Well, we just put both of them on the same day.
I'm traveling 21st through the 25th.
No, but no, it's not gonna be on the 22nd. Just give them 30 days. Put it, reset 30 days from the day.
Both cases, right?
Yeah, both cases, so it'll be on the.
Jennifer Thompson, I don't know her.
Martin Cruz?
He's present, Your Honor.
Okay, Mr. Cruz, your full name is Martin A. Cruz?
Yes, sir.
How are you doing, Mr. Cruz?
Doing all right.
That's good. Mr. Cruz, you're represented in your case by your attorney, Kevin Lane. Mr. Lane, how are you doing?
I'm fine, Your Honor, thank you.
Okay, now, Mr. Lane, what's your announcement in Mr. Cruz's case?
Your Honor, We're asking for a jury trial in this case.
Okay?
However, we have gotten a previous court order, and I've spoken to the state about it, and I realize that there is some confusion about this because the lab is at the hospital as opposed to the DPS lab, prime lab. And I know that these boilerplate rulings are a little confusing for the court. With or without it, we are still asking for the credentials of the lab and their procedures and other matters regarding his blood that was taken at the lab. We are still asking the court to produce as much as they can on that, but we are still wanting a jury trial on this. So I guess what we're asking the court for is maybe a clarification regarding the standard local discovery order for blood records as it pertains to the hospital's lab.
When you're saying a clarification, you're talking about the court, that's a standard order by all courts in Jefferson County. So all the courts would have to make a standard order. I mean, you would have to draft up something. We could have a hearing on it and check the law on it.
Or Your Honor, and maybe a better way to address the court on this is if they will interpret the order, the state will interpret the order the way they interpret it and produce what they can. And then if we object to an incomplete discovery, that way we can do that. And in the meantime, we'd have a trial date.
I would think the better practice would be just subpoena the records of the hospital.
Well, from the medical records,
Right.
that would be correct.
Yeah,
And
subpoena Deuces Tika.
that would be, since it is a private
Right.
entity on it.
It's not
We
a
have
state.
no control over their lab or their
Right.
testing, nor their certification. That would be purely medical, that would be purely on the medical front. That
Right.
was given and for the purposes again of treatment. If he wants to question their lab or the hospital's method of testing, qualifying, for like their blood, that would be a totally separate and outside of I think our scope here, Judge. We have like the analysis with that, we have the whole blood analysis and the serum blood. That is up to, they're welcome to call someone from the hospital, but all we can provide, and I think it is the extent of the state's obligation, is just to provide whatever medical records which we had subpoenaed, but as far as their lab or their certification, national or the state, that's just beyond our purview and is utterly inapplicable for the standard order to apply to a private entity, Judge. That's
Your Honor,
our
if
position.
the clarification from the court here and to all other courts is that this standard order does not apply to a lab and a hospital, that's a qualification. I just want to know from here and into the future that
You
if
can find that out from the hospital, whether or not that applies to them.
okay, so
They can
if
tell you
this-
whether or not they're going to comply with that order or not. If they do not comply, then we come back and then we can reevaluate, we look at the law.
So
If
this
the
order
project-
states the district attorney's office and its agents, the forensic laboratory that analyzed it in this case, should copy and produce. It's order requiring them to get that information.
No, Judge, it is not a forensic laboratory. When they test in blood in the hospital, they use it to type the blood, to classify it from lighter blood, or to use blood for treatment. That is totally independent. This is if we use a lab, a private lab, which we have either blood tested or drug tested, we contract out. We do not contract out with the hospital. So let me distinguish between that. You having a private lab, right, or a hospital. That is a private entity.
Your Honor, my only response to that is, and I have done some research on that, whether or not this order would apply to only a forensic lab or the hospital lab. If they would like to change the court's order that you already, then they should do the briefing on that, and we should have a hearing on it. In the meantime, we can have a trial date. But right now, they are ordered to go get that information from the lab in this case, in my opinion.
That order is not, well,
Well,
let me say unequivocally, Judge, it is not within the state's purview to order again a private lab where we've not contracted. When a person was at a hospital and the blood was drawn, Judge, at a hospital, that is not a forensic laboratory. The order is utterly inapplicable. And he cannot impose upon the state, again, it would be a super burden, Judge. We cannot order Christus, Baptist, any other hospital to what are your lab protocols? And it's not even, let me say this unequivocally. A hospital lab would not be subject to a forensic laboratory of the state. They're totally separate purposes, Judge. One, again, is forensic evidence for the testing of evidence. The other is for medical treatment and medical purposes only. Two different, and I submit to this court, the state will not certify a hospital lab for purposes of testing blood or any for drugs or anything else, Judge. We do not have that burden. That audit does not address treatment for medical purposes.
Your Honor, to respond to the state, the hospital record said this essay, the ethanol finding, it says is intended for medical use only and should be correlated with clinical findings, which says to me, this is not a forensic finding of the blood alcohol concentration. So we would object if the state is not going to bring these records in to prove that Mr. Cruz was above the legal limit of blood alcohol concentration. If they're not going to bring that evidence, then we don't need that.
First of all, there's a difference between serum blood and whole blood and how there's a whole different calculation
Yes,
when it's used for medical.
I understand the different
in the
calculations.
medical. That's why therein lies the difference between ordering a forensic laboratory or a hospital. Of course, we're going to use those findings, Judge, but they're totally separate calculations, which he's welcome to have, he's welcome to subpoena anyone to also to explain the difference. But there's a difference between whole blood, which is used in the hospital, and the serum blood, which we also have to use like for testing. I'll say it once again, and I'll conclude by saying the standard order is utterly inapplicable to to hospitals.
We oppose that interpretation, but if the state would like to brief that out, and I've briefed some of it out, Your Honor, and frankly, I don't know. And I've talked to the state's attorney. So we would want a jury trial setting, and then if they'd like to set another hearing on.
So you want to set a trial setting before this is
Well, it's up to the court. I mean,
no. I mean, it's up to you if you want to.
I just don't want it to have the extra burden of going and getting that information when the court's already said they have to get it. And then they said, well, but this doesn't apply. So.
It's an effort in futility. You see from the research was done, if something is utterly inapplicable, Judge, I don't mind doing preliminary research, but
I'll tell you what,
we can set it for
this is
trial.
what we do.
We could have a hearing.
No, this is what we're gonna do.
Before
I'm
trial.
gonna set it, reset it 30 days, give both of y'all the opportunity to submit to me a brief. Okay?
Okay, we will respond to the state's brief, Your Honor.
But see, no.
Here's your, they have
Wait up, hold on.
they have a duty to.
Lower your voices, lower your voices.
And I'm sorry.
This is okay when it comes to the law. He's asserting that we have an obligation in that order. We should respond. Let him find the research and allow, he's making the assertion, Judge, that we have to be compelled to supply private hospital medical records of their laboratory, in order for him. Let him make that initial, it's his motion. He's seeking that relief. Let him create the initial finding for us to respond. That burden would be on him, Judge. Now, if you want to suggest a brief solely on does a standard court order, if we're going to just focus it on this, right? Does a standard court order, which is directed to a forensic laboratory, applies to a hospital dealing with medical, we can limit it like to that, Judge.
Yes, Your Honor, and we will respond to their response. In other words, they do the briefing and saying that this order, and then I will then respond to,
Well, but I
it's
think-
their order to give the information.
We're not going to
not
give the
necessarily.
information, Judge.
No, I mean, you can, like I say, I think the burden will be on you to submit the order.
Okay, well, then
do a
this
brief-
order, then you're rescinding this order is what you're doing.
That's your
not-
words. Did
Well,
you hear
you
rescind come out of my mouth?
Well, I mean, you signed.
I didn't say, I didn't say nothing about that. You putting all of these words out there into the records. I didn't say that.
Right.
I said, go and get a brief.
You're right.
You said you already did research.
I have, Your Honor. I
Okay,
have.
just do a brief on it and then let the state respond. That's simple.
Oh,
as
so
that.
you want me to brief and then?
You already did research.
All right,
You say, I mean, it's just like a person filing a motion to suppress or something. Okay?
I got you.
It's the burden will be on that person because right now it's saying it's the order is to a forensic lab. The hospital is not a forensic lab.
Well, nobody knows that yet.
Okay, well, you can brief it.
All right.
Okay, and we'll give you, how much time do you need to brief it? I'm not going.
Oh, well, I've done
some
some brief. 30 days is okay.
Okay, so we'll do that, and then the state will have an opportunity to respond, and then we'll have a hearing on it. Okay, but right now, we just. I just want to keep it on the announcement docket,
Yes, sir.
okay? And then once we get through this here, then we can go to a trial docket. Okay, once we get over this issue.
Yes, sir.
Okay,
I'll try to get a brief,
or it just take it,
at least within 10 days of our setting, if that's okay.
Oh, that's right.
Okay.
That's right. Okay, so we'll just reset this here for 30 days. If you need additional time, just let the court know,
I appreciate
and
it.
we'll be able to give additional time.
Sorry for raising my voice.
Okay.
We just,
I just y'all in the heat of battle. Yeah.
good on the law.
Okay, let's go ahead and get it reset.
Thank you.
Mr. LeBlanc. Oh, wait up. Who is, Jaguar and Neville? Neville, okay.
Yeah, it's not. Oh, sorry, you don't know that yet. That's a lot easier.
Okay, Jefferson County Court at Law number 2 is in session and cause number 25 CCCR 1898. Case to style the state of Texas versus Taylor Monet Neville. Ms. Neville, is that your full name?
Yes.
Ms. Neville, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Neville, you may put your hand up. How are you doing, Ms. Neville?
Going.
That's good. Ms. Neville, you are represented in your case by your attorney Todd LeBlanc. And Mr. LeBlanc, how are you doing?
Good, Judge, thank
Mr. LeBlanc, do you waive a record in Ms. Neville's case?
We do, Your Honor.
Ms. Neville, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Taylor Monet Neville, on or about June 4th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury. Ms. Neville, do you understand what you have been charged with?
Yes, sir.
To this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading
No
guilty?
contest, I'm sorry.
No contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Neville, I also have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials TW on a line
TN.
T.
TN. It looks
T
like
N. Oh, it's yeah, okay.
Yes,
I see how you wrote it. Okay, the initials are T N. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this
Yes,
document?
sir.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are two boxes checked. First box check states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box is check states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Also have a document on paper that is titled. Oops. That's titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line as not a
Yes, sir.
defendant? Ms. Neville, before you sign and initial all of these documents, did your attorney go over these documents with you?
Yes, sir, it is.
And did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Ms. Neville, are you a citizen of the United States?
Yes, sir.
State Officer State's Exhibit 1.
No objection. State's exhibit number 1 will be admitted. Ms. Neville, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
And Mr. LeBlanc, you advised and counseled Ms. Neville. Is there any evidence that she is currently mentally incompetent to stand trial? Ms. Neville, I will accept your plea of no contest. I will also find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement?
Essential terms are as follows: 15 months deferred, $500 fine, 60 hours community service, anger management, and no contact with the complaining witness, Marshall Washington.
What's the court cost? $337?
You got it. That's why I It's a here strong crystal.
Okay. Ms. Neville, the state is offering that you serve 15 months deferred adjudicated probation. During the 15-month probationary period, you'll be required to pay a fine of $500 plus court costs of $337. You'll be required to pay probation fee of $60 a month. Your analysis fee, $15 a month, reimbursement fee of $15. And Mr. LeBlanc, were you appointed?
I will, Judge.
Okay.
What's the first name?
You'll also be required to reimburse Jefferson County court-appointed attorney's fees of $350. Your total monthly installments, that is a total amount that you will be required to pay each month while you're on probation, is $166 a month. Are you able to pay the $166 each month?
Sure.
All right. You'll also be required to perform 60 hours of community service. You cannot have any contact with the complaining witness, Marcel Washington, and you'll be required to adhere to the other standard terms and conditions of this probation. Ms. Neville, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir, I do.
Ms. Neville, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Neville, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction in your record, and you may qualify for non-disclosure, where your record will be sealed to the general public. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Ms. Neville,
Yes, sir.
you stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you'll have a blessed day.
Okay, thank you.
Thank you. And Mr. LeBlanc, is this your only case? You're free to go as well and you have the best day. Miguel Angel Ben Harper. What?
What is his name? Mr. LeBlanc.
Well, she gonna have to sit down. Who was the prosecutor?
The 166 old,
How you pronounce your last name?
Menjivar. Menjivar.
Menjivar. Okay. Okay, this is cause number 26 CCCR 1464. Case is style of state of Texas versus Miguel Angel Menjivar. And Mr. Menjivar, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Menjivar, you may put your hand down. How are you doing, Mr. Menjivar? I'm fine, thanks for asking. Mr. Menjivar, your attorney of record in this case is attorney Todd Takash. Attorney Takash is not here, however, standing in for attorney Takash is attorney Sean Head. Does Mr. Head have your permission to stand in for attorney Takash?
Yes, sir.
And attorney Head, how are you doing?
Good, Judge. How are you?
I'm doing fine, thanks for asking. And attorney Head, do you waive a record in Mr. Menjivar's case?
Yes, sir.
Mr. Menjivar, let's see. Blank. Okay, Mr. Menjivar, I have before me on my computer a document that is titled complaint. This complaint actually was filed by Texas Department of Public Safety. This complaint alleges that you, Miguel Angel Menjivar, on or about April 18th of 2026, while you were in Jefferson County, Texas, that you committed the offense of speeding at 10% or above posted speed. Mr. Menjivar, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Menjivar, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Menjivar, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
Now, in this first page of this document, there's one box that's checked. The box that's checked states that this is a Class C appeal. Now, going to the next page. And I'm going to insert a word. The word I'm going to insert is complaint. Because you're not charged by information, but you're charged by complaint. And matter of fact, I'll just put my initials there. I just would say that you're charged by complaint. Now, are those your initials on line 2 next to a box that's checked? No look contingent, which means no contest.
Yes, sir.
That's wrong.
And on page 3 of this document, there's a signature above the line that's titled defendant. This is your signature.
Yes, sir.
And on the next document, this next document is titled Trial Court Certification to Defendant's Right of Appeal. Do you recognize this document?
Sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand this statement?
Sir.
Second box is checked, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
Yes, sir.
Okay, Mr. Minjavore, I also have a document that is titled Discovery Certification. Do you recognize this document? Is this your signature on the line that's titled defendant?
Sir.
Mr. Minjavore, before you signed these documents, did your attorney go over these documents with you?
Sir.
And did you understand everything that your attorney went over?
Sir.
Is everything in these documents true and correct to the best of your knowledge?
Sir.
Mr. Minjavore, are you a citizen of the United States?
Sir.
State, like to offer states one?
So move, Your Honor.
Any objections?
No objection.
No objection, states exhibit number 1 will be admitted. Mr. Head, you advised in counsel, Mr. Minjavore, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Minjavore, your attorney, Mr. Sean Head, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
And your attorney, Mr. Todd Takash, is also advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Mr. Minjavore, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, we have a plea bargain agreement.
Yes, Your Honor.
And what is that agreement?
The essential terms are as follows: $275 fine, plus court costs.
Okay, what's the court cost? Okay. Mr. Minjavore, the state is offering that you serve, well, actually that you pay a fine of $275 plus court costs of $277, which comes to a total of $552. Are you able to pay the $552?
Yes, sir.
Okay, now, Mr. Minjavore, do you understand the state's offer?
Yes, sir.
And do you accept the state's offer?
Sir.
Ms. Minjavore, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Minjavore, you're gonna stand next to the bailiff, follow her directions. Once you follow her directions, you're gonna go downstairs to our county clerk's office, make that payment, and then you'll come back upstairs with the receipt and get that receipt to the court coordinator. Once you do that, you're free to go and you have a blessed day.
Sir.
All right,
Thank you, Judge.
thank you. Patrick Cody Schroeder.
Miss Kepler,
Yeah.
to go to the funeral.
Hmm?
My client, Miss Kepler.
Kesterson, yeah. What are they doing? What are they doing on that? Is they,
Well, we're gonna do a plea, on Friday.
okay,
Okay, and she just.
so y'all just tell her, reset it for plea on Friday. Kesterson, Marva Provo, Mr. Gerst,
Morning, Judge.
good morning. Okay, who's the prosecutor?
Who's next to this? Is the playground? Yeah.
Schroeder. I can share the lead. Schroeder, Patrick Schroeder, you need to see the plea agreement. This is cause number 25CCCR 1108. Case is style of state of Texas versus Patrick Cody Schroeder.
Oh.
Ms. Schroeder, Mr. Schroeder, is that your full name?
Yes, sir.
Mr. Schroeder, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Schroeder, you may put your hand down. How are you doing, Mr. Schroeder?
Pretty well myself.
I'm fine. Thanks for asking. Mr. Schroeder, you're representing your case by your attorney, Ryan Gertz. And Mr. Gertz, how are you doing?
Great, Judge. Thank you.
That's good. Now, Mr. Gertz, do you waive a record in Mr. Schroeder's case?
Yes, Judge.
Mr. Schroeder, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Patrick Cody Schroeder, on or about October 19th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place in Jefferson County, Texas. Mr. Schroeder, do you understand what you have been charged with? To this charge, how do you plead? Guilty, not guilty, no contest?
Guilty.
Guilty. Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes.
Okay, Mr. Schroeder, I also have before me a document that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that says guilty. You place your initials on this document.
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
It is.
defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
defendant?
sir.
Schroeder, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Schroeder, are you a citizen of the United States?
Yes, sir.
State office, sorry, state office, State's Exhibit 1.
Any objections?
No, Judge.
No objection. State's Exhibit Number 1 will be admitted. And Mr. Gertz, you advised and counseled Mr. Schroeder, is there any evidence that he is currently mentally incompetent to stand trial?
None at all, Judge.
And Mr. Schroeder, your attorney, Mr. Gertz has advised and counseled you. Are you satisfied with his representation?
I am.
Mr. Schroeder, I will accept your plea guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
Essential terms are as follows: 180 days county jail, probated over 15 months. a $750 fine, 60 hours community service, and DWI standard terms and conditions.
Have a great day.
What's the court cost? $450. Okay, Mr. Schroeder, the state is offering that you serve 180 days in Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $750 plus court costs of $452. You'll be required to pay a DWI conviction fine fee of $100. You're required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DW Education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is a total amount that you will be required to pay each month, is $178 a month. Will you be able to pay the $178 each month?
Yes, sir.
You will also be required to perform 60 hours of community service, attend and complete a DW education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. Mr. Schroeder, do you understand the state's offer?
I do.
And do you accept the state's offer?
Yes, sir.
Mr. Schroeder, I'll follow the people are in agreement that you have entered into with the state. Schroeder, you'll stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go. And you have a blessed day. Ryan Pete,
Judge, he's, on Zoom here.
okay. Mr. Pete, you can take your mic off of mute. Ryan Baxter Pete. Be able to hear me. Okay, Mr.
Stuff.
Burris, what's your announcement in Mr. Pete's case?
I got a new offer from the state this morning. I needed to discuss it with him, so they asked for resetting 30 days, Mr. Pete.
Okay, give us a reset date. What is that? Oh, August 12th. Okay, Mr. Pete's case will be reset to August 12th, 2026. And Mr. Gertz, is this your last case?
No, Judge, I've got another plea and another,
Oh, you did?
announcement.
Let's see. Is that Alvarez?
Yes, sir.
Okay. Ricardo David Alvarez Jr. Court is in session in two cases. Cause number 25 CCCR 1781 and cause number 25 CCCR 8-0. Both cases are styled the state of Texas versus Ricardo David Alvarez Jr. Mr. Alvarez, is that your full name?
Yes, sir.
Mr. Alvarez, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Alvarez, you may put your hand down. How are you doing, Mr. Alvarez?
Yeah, how you, sir?
I'm doing fine, thanks for asking. Mr. Alvarez, you're represented in your cases by your attorney, Attorney Ryan Gertz. And Mr. Gertz, do you waive a record in Mr. Alvarez cases?
Yes, Judge.
The state is represented in this case by Attorney Samuel Masranian. Mr. Masranian, how are you doing?
Doing well, Judge. Thank you.
You're welcome. Now, Mr. Alvarez, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ricardo David Alvarez Jr., on or about May 18th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury to a family member. Mr. Alvarez, do you understand what you have been charged with?
Yes, sir.
To this charge, Ms. Alvarez, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes, sir.
Okay, Mr. Alvarez, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document? On page 2 of this same document, there's a set of initials on the line next to a box that's checked guilty. Did you place your initials RA on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document? And is this your signature? At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have another document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Alvarez, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Alvarez, are you a citizen of the United States?
Yes, sir.
State Officer States Exhibit 1, Your Honor.
Any objections?
No, Judge.
No objection states exhibit number 1 will be admitted. Mr. Gertz, you advised and counseled Mr. Alvarez. Is there any evidence that he is currently mentally incompetent to stand trial?
None at all, Judge.
And Mr. Alvarez, your attorney, Mr. Gertz, has advised and counseled you. Are you satisfied with his representation?
Very well.
Has he provided full, effective, and competent legal representation?
Okay.
Mr. Alvarez, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
That'd be 2 years deferred adjudicated probation, the $400 fine, 50 hours of community service. Mr. Alvarez must attend and complete the batterer's intervention and prevention program, and no contact with the complaining witness in this case, Doris Guevara. Oh, and in addition to, for Mr. Alvarez's plea in this case, the state will be dismissing the companion case, cause number 25 CCCR 1781.
What's the court cost?
Yeah.
Okay, Mr. Alvarez, the state is offering that you serve 2 years deferred adjudicated probation. During this 2-year probationary period, you'll be required to pay a fine of $400 plus court costs of $287. You'll be required to pay a probation fee of $60 a month. You're not $15 a month, reimbursement fee of $15. You'll also be required to pay $100 to a crime victim center, a family violence center in Jefferson County. Your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation is $109 a month. Will you be able to pay the $109 each month?
Yes, sir.
You'll also be required to perform 50 hours of community service. You have to attend and complete the Batters Intervention and Prevention Program. And you cannot have any contact with the complaining witness, in this case, Doris Guevara. And you'll be required to adhere to the other standard terms and conditions of this probation. Mr. Alvarez, do you understand the state's offer? And do you accept the state's offer? Mr. Alvarez, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Alvarez, if you successfully complete this probationary period, this case will be dismissed. It will not result in conviction in your record. And you can talk to your attorney about a non-disclosure where your record will be sealed. He's quite competent in those matters, and the state will be dismissing cause number 25 CCCR 1781. Okay, please stand next to the bill. Can you have a blessed day? You're free to go. You will.
Did you see the place? No, right.
Okay, let's see. Hope. Brenton Allen Hope. Mr. Hope, your full name is Brenton Allen Hope.
Yes, sir.
How you doing, Mr. Hope? You're blessed. That's good. Could not be better than being blessed. Now, Mr. Hope, you're represented by your attorney, Brian Gertz. Mr. Gertz, what is your announcement in Mr. Hope's case?
Judge, we're asking for a little additional time. I've asked Ms. Nixon to look into a couple of things on this case, and obviously she's been in court and had to have a chance to do so. So
Okay.
could we maybe have 30 days or so?
Okay, the standard reset. Okay, this case is reset to August 12th, 2026. Mr. Hope, you get your reset from our court coordinator. Once you get your reset, you're free to go. And you have a blessed day. Mr. Gertz, you're gonna have
That's
to,
fine.
yeah, make sure you contact Ryan Pete to let him
Yes.
know that,
It'll be funny when he comes on. We were all talking about you, Ryan.
yeah. Okay. Okay, you're free to go. You have a blessed day. Okay, Tawana Lejay.
Hello, sir.
There he is. Hey,
This
hey,
is Ryan
your
P. I
case
am
is being
so-
reset.
Thank you.
Okay, Mr. Pete, your case is being reset. Stay in contact with your attorney and your bondsman.
Yes, sir. Thank you very much. I'm so sorry I didn't respond.
Okay,
I hope y'all have a great day. I'm
all
sorry.
right, same to you. Now, Ms. Leger, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
Or these are the initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Ms. Leger, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Oh,
Then we have to, Miss, okay, we're gonna do it Albert Price. Because Albert Price yesterday, we had to, take him back. Okay, Miss, Leger. The court read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Albert Price. Attorney Price will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. You're welcome.
But it's not for them because it's not.
There you go.
One year, contract law. That has to be. You have to be like this.
Jamal DeVar Collins.
Did it print off, sorry. No, it was really short. Thank you so much. How you doing this morning, sir? I'm well. I'm well, thank you.
And your attorney's something is out. This is usually 21.
You better not do it.
I haven't been that person before you. This is a dimension.
Man. No, in the computer, on my page, it has everything saying Beaumont Municipal Court, and then when you look up the complaint, it said the city of Port Arthur.
I couldn't tell you, Judge. I don't.
Let me see where it occurred. I mean, we had that once before. They had two. It was filed twice. I mean, not on him, but in another case where one was said City of Port Arthur, the other one said Beaumont. I need to figure out this one.
In our file, it has it in Port Arthur.
In Port Arthur? Okay, whoever inputted this information in the clerk's office labeled it all wrong.
Oh, yes, I've been doing.
Yeah.
Man.
Appointments under ordinance.
No, I'm looking at, all this says Beaumont Municipal Court, everything, but it happened in Port Arthur. Let me go to the complaint. Okay. Mr. Let's see. This is cause number 26 CCCR 1466. Case and style of state of Texas versus Tramal DeVore Collins. Mr. Collins, is that your full name?
Yes, it is.
Mr. Collins, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Collins, you may put your hand down. How are you doing, Mr. Collins?
Doing well. How are you doing?
I'm doing fine, thanks for asking. Mr. Collins, you're representing your case by attorney Sean Takash, attorney Todd Takash. Attorney Todd Takash is not here. However, standing in for attorney Takash is attorney Sean Head. Does attorney Head have your permission to stand in for attorney Takash?
Yes.
Okay, and attorney Head, do you waive a record in Mr. Collins' case?
Yes.
Mr. Collins, I have before me on my computer a complaint that was filed by the city of Port Arthur. In this complaint, it alleges that you, Tramal DeVore Collins, on or about February 13th of 2026, while you were in the city of Port Arthur in Jefferson County, Texas, that you committed a Class C misdemeanor offense of failed to control speed. Mr. Collins, do you understand what you have been charged with?
Yes.
And to this charge, how do you plead? Guilty, not guilty, and no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you're guilty?
Yes.
And okay, Mr. Collins, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there's a set of initials on the line next to the box that check guilty. Did you place your initials on this document?
Yes.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, it is.
And on the next document that's titled trial court certification of the defendant's right of appeal, you recognize this document?
Yes.
And is this your signature?
Yes, it is.
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right to appeal. Do you understand that statement?
I do.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, I do.
Now, Mr. Collins, before you sign and initial all of these documents that I just showed you, did your attorney go over these documents with you?
He did.
And did you read and understand everything that he went over?
Yes, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Collins, are you a citizen of the United States?
I am.
State tender to this honorable court, State's Exhibit Number 1.
Any objections?
No objection.
No objections. State's Exhibit Number 1 will be admitted. Mr. Head, you advising counsel, Mr. Collins, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Collins, your attorney, Mr. Head, has advised and counseled you. Are you satisfied with his representation?
Yes.
Mr. Collins, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The essential term is as follows. It's a $50 fine plus court costs. That's correct, Mr. Head?
It is, yes.
Okay. Let's see. Mr. Gertz, before you leave, I need to give you something. No. That's for Mr. Alvarez.
Thank you, Judge.
Okay,
Okay, yes, sir.
okay,
Thank you.
okay. Okay. So, State, could you repeat that offer?
$50, Your Honor, plus court costs.
Okay, and what is the court cost in this case? 277. Okay, Mr. Alvarez, excuse me, Mr. Collins, the state is offering that you pay a fine of $50 plus court costs of $277, which comes to a total of $327. Are you able to pay the $327?
Yes,
Okay, now, Mr. Collins, do you understand the state's offer?
I do.
And do you accept the state's offer?
Yes.
Mr. Collins, I'll follow up. You are in agreement that you have entered into the state. Mr. Collins, you're going to stand next to the bailiff, file her directions. Once you finish filing her directions, you're gonna go downstairs, make the payment, and then bring the receipt back up to this court and give it to our court coordinator, and then you'll be free to go. And you have a blessed day.
Thank you.
Okay.
Thank you so much.
You're welcome. Devin Bell.
Yeah.
Yeah. Okay, this is cause number 266CR 1074, case of style of state of Texas versus Devin Casey Bell. Mr. Bell, is that your full name?
Sir.
How are you doing, Mr. Bell?
Very good. How about you?
I'm doing fine. Thanks for asking, Mr. Bell. You're representing your case by your attorney, Takash. Attorney Takash is not here standing in for Attorney Takash. His attorney, Sean Head. Does Mr. Head have your permission to stand in for Attorney Takash?
Sir.
And Mr. Head, what is your announcement in Mr. Bell's case?
But we would just like a short reset. The state is gonna look into something for the case and then it should be resolved.
Exactly. Okay.
At the next.
Okay. Give us, is that correct, Saint?
Yes, Your Honor.
Okay, give us a reset.
August 12th.
Okay, this case will be reset to August 12th, 2026. Mr. Bell, you'll get your reset from our court coordinator. Once you get your reset, you're free to go. And you have a blessed day. Thank you. And Mr. Head, I think this is your last case.
It is, Judge.
You're free to go, and you have a blessed day. I need some more copies of this. Okay. Any more, we have any more lawyers? Oh. Did he, is he going to plead?
I don't have any.
Thank you.
Mr. Cole,
Yes, sir.
what are we doing in your case?
We are going to, it's been signed.
Yeah, okay.
Yes.
Well, as soon as we get it, we'll call, Mr. Pugh up.
Sounds good.
Okay. Okay, Billy D. Corral.
Good morning, Your Honor.
You standing in the front. How are you doing, Ms. Correll?
I'm kind of nervous. My attorney's not here. but-
She's on Zoom. Yeah. Ms. Perazzo, how are you doing?
I could be better, Your Honor, but I'm here.
Okay, well, that's good. Now, Ms. Correll's case is set on the court's announcement docket. And Ms. Perazzo, what is your announcement?
So, Your Honor, she was actually set to plead today, and she was going to be taken into custody to do her 72 hours. But unfortunately, due to my car issues that were unexpected, I'm still at the mechanic shop and I cannot get there to do the plea paperwork. I am scheduled to be in your courtroom tomorrow. So I don't know if we could reset her case to tomorrow morning to hopefully dispose of it.
Hmm?
I wouldn't have a way here.
She said she doesn't have a way here tomorrow.
I could send it off for.
Okay.
Later date.
And again, I apologize. It's just out of my control.
Okay.
I just rely on someone else.
Understand.
And it's not her fault.
Yeah, I understand.
What can accommodate, the state is. you know,
Yeah, I'm
we
trying to
have no
figure out
case.
now.
What can accommodate you? Turn.
I mean, I could come in a couple of weeks, a month, I mean, whatever's fine. I just have to.
I'm just about
I
maybe
can't
sitting
hear
in
what
1 week.
she's saying. I'm sorry.
Okay, she said we're gonna reset it 1 week. Okay, Ms. Perazzo?
Yes, sir.
Okay, this case will be reset to July 15th, 2026.
Oh, Your Honor, I'm sorry. I actually have I didn't realize I have a deposition that morning with Mel Shalander at 9.
Okay,
That could be all day.
He's deposing my client.
yeah, I understand. The next day is a Thursday, isn't it? What about the 16th?
That will work.
Okay, so we're gonna reset it for July 16th at 9 a.m. You get your reset. Once you get your reset, you're free to go. And you have a blessed day, set for plea. Okay.
Continue
Your Honor.
Continue.
Oh, let me see. Yes, the AANA. Let me see.
I have to go onto a separate sheet.
Oh,
I can, sheet.
let me see it.
It's fine.
Yeah.
I remember she did it before, you know.
We're gonna need to make it.
That's the most recent. I think we copied them the last time, correct,
Yeah,
Judge?
those are the
We
recent
copied those
ones.
from before.
We copied
This
these?
is- No, sir.
Some other
We
ones?
copied these, Judge.
White paper, you didn't copy the one on yellow paper, that's
Copy
the
that.
new one.
Okay.
Those are new ones those are all the ones I've attended this month.
Yeah, by,
That's great, but
Buzzing.
it's the same as what it was.
here you go.
Yes, sir. Okay.
Let me, give you,
I just do them all by Zoom.
Yes,
so
ma'am.
I can-
here you
That
go.
makes perfect sense. We understand. from
Let me give you-
The qualities and stuff. Yes, ma'am.
Could you pass
You've
these?
been doing an excellent job, ma'am.
Okay.
No, maybe. no.
Yeah.
I
Well,
actually
yeah, just keep up the
posted
good
this
work.
one And didn't find it until a couple days after I've been doing that one.
Okay,
Okay.
You've
that's
been very
good.
diligent.
Yeah, just, have a seat. Your case is reset to July 6th,
Okay.
2026 at 9 a.m. We're gonna give you your, form back. Oh, that's your right?
That's my right.
Okay, we got to give another date.
Yeah.
What day of the week was that? Was it about Friday? Oh, she had, her ride has a doctor's appointment, so we got to give her another date, Ms. Perazzo.
Okay.
What about that?
Next week.
July 20th, Ms. Perazzo.
Let's see.
I was thinking,
I mean, I'm good with anything.
oh, you are, okay.
I have a final hearing in the 88th district on that
Do we
day.
have anything that Friday before that? Let me see.
The 21st, 22nd.
That's it.
Huh? What about the 21st, 22nd? What about?
Okay, 21st.
She said 22nd would be better.
22nd.
Hold on, let's check with her schedule too.
Yes.
I will actually be there. on the 21st in your courtroom.
21st, okay. So it'll be reset to the 21st. Okay, so your case is reset to July 21st, 2026. You get your reset. Once you get your reset, you're free to go and continue to keep up the good work. You have a blessed day. Okay. And Yancy Herring. Ms. Herring, how are you doing?
Good, how are you?
I'm doing fine, thanks for asking. Ms. Herring, you're represented by Attorney Laura Perazzo, who is appearing via Zoom. And Ms. Perazzo, what's your announcement in Ms. Herring's case?
So, Your Honor, we just received all of the letters of recommendation that we were trying to gather before I sent over my pretrial diversion request. And so now that I've received all of them, I will be making that pretrial diversion request.
Okay, ma'am, that door is locked. Okay, could we give us a 30-day reset? Okay, this case will be reset to August 12th, 2026. Ms. Herring, you get your reset from our court appointment. Once you get your reset, you're free to go. And you have a blessed day. Stay in contact with your attorney and your bondsman.
Yes, sir. Thanks.
You're welcome. And Ms. Perazzo, I think that's your last case.
Yes, sir.
You're free to go as well, and you have a blessed day.
Thank you. You too.
Okay. You get your reset. Your case is reset to July 15th, 2026. Your attorney is currently in Galveston, Texas, in court. Once you get your reset, you're free to go. And you have a blessed day.
Thanks.
You're welcome. Put a big recess. See. Court is back in session. This is cause number 24 CCCR 2080, case of Styles, State of Texas versus William Pugh. Mr. Pugh, is that your full name? Mr. Pugh, would you please raise your right hand? Mr. Pugh, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Pugh, you may put your hand down. How are you doing, Mr. Pugh? That's good, Mr. Pugh. I'm doing fine. Thanks for asking. Mr. Pugh, you're represented in this case by your attorney, Attorney Giles Cole. And Mr. Cole, how are you doing?
Great, Judge. Good to see you.
Nice to be seen. And Mr. Pugh, well, Mr. Cole, do you work a record in Mr. Pugh's case?
Yes, sir.
Okay, Mr. Pugh, I have before me on my computer document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, William Pugh, on or about July 21st of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of unlawfully carrying a weapon. Mr. Pugh, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Pugh, how did you plead? Guilty, not guilty, and no contest?
No.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Pugh, I also have before me a document that is titled misdemeanor plea admonishment that is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there's a set of initials WP on a line next to a box that's checked no contendere, which means no contest. Just place your initials on this document. On page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes.
And on the next document, that's titled, that's not your signature, that's your initials. That's your signature on it. You just need to change, erase where it has his initials and place his signature. His signature was on the next page.
Yes, Sean. I gotta get this straight for you.
Just, okay. Now, Mr. Pugh, is that your signature above the line that's titled defendant?
Yes, sir.
Mr. Pugh, on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature?
Yeah.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. You understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Yeah, I had a discovery certification.
Yes, we do.
Okay, Mr. Pugh, I have another document that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes.
Now, Mr. Pugh, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Pugh, are you a citizen of the United States?
Yes, sir.
State, would you like to offer State's Exhibit number 1?
So move, Your Honor.
Any objections? No objections. State's Exhibit number 1 is admitted. Mr. Cole, you advised and counseled Mr. Pugh. Is there any evidence that he is currently mentally incompetent to stand trial?
No, sir. No, he's not, John.
Mr. Pugh, the attorney, Mr. Cole, has advised and counseled you. Are you satisfied? Are you satisfied with his representation?
Yes.
Mr. Pugh, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt statement. Do we have a plea bargain agreement in this case?
Yes, Your Honor, we do.
And what is the agreement?
The agreement, in this case, the central terms are as follows, 6 days in jail. However, the defendant has served, 6 days in jail, and, the state will, offer the credit for the time served and the court cost to be taxed and retired.
Okay. And I have a motion.
Yes, sir. At this time, the state moves to confiscate and destroy the weapon associated with the style case. The firearm is styled SN TDP as in Paul 21871.
Okay. Let's see. Mr. Pugh, state is offering that you serve 6 days in Jefferson County Jail. You don't have to serve any more time in the Jefferson County Jail because you've already served 6 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. State has filed a motion in order to confiscate and destroy this weapon pursuant to Article 18.19. Court is going to grant this order. And so therefore, the court is ordering that the weapon that's in the possession of the Beaumont Police Department, they have it.
Yes, sir. Yes,
Okay.
sir.
Be confiscated and destroyed. Okay? Mr. Pugh, do you understand the state's offer? Do you think the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer? Okay, Mr. Pugh, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Pugh, I see that you're here with someone. Who you here with? You're here with your mother. Okay, Mr. Pugh, how old are you?
22.
22. You probably would not believe this, but I used to be 22. I was 22 for 365 days. Okay. When I was 22, I had friends. And I know you have friends too, right?
Not anymore.
You don't have no friends
Besides my kids,
besides your kids. So you had friends.
those kids, they wasn't really no friends.
Okay. You said it was associates.
Things found things out the hard way. Been alone.
You found out the hard way. And okay, you found out the hard way. I probably, when you found out the hard way, you probably realized what your mom was probably had been telling you all your life. Okay, the things that you just ignored. But you know, a lot of times young people tend to think that they're smarter than their elders. You know, you think that, you know, a lot of times because you have computers and all of these other electronic things, you say, oh, you know, these old people, they can't operate it. We smarter than them. But you know who invented those things that you're using? Old people. Invented them. You just using what we invented. Okay, so who's the smartest? I'm just saying, if you were so smart, you'll be able to invent it. But we invented those things, our generation. Okay, and so I say that to say this: a lot of times, you know, a lot of things that you do in your life, where you're going in your life, your mom and older people have already been there. And when your mom is when your mom tells you what to do and not to do, it's because of the experience that she had. Okay, she's been there and done that. You know, they said, you know, the Bible said there's nothing new under the sun. You would not believe this. You probably would not believe this also. Guess what? When I was 22, I used to have hair on my head. That's hard to believe.
You thought you was born like that.
But you know, so only thing I'm trying to say is that you know, where you going, she's already been. We've already been. And so we're looking through a rearview mirror and we're trying to tell you what's in the rearview mirror for us is what's ahead for you. And we're trying to tell you what lies ahead. That's what she's trying to do. So you could avoid those pitfalls. Okay? Your friends probably was telling you, oh, you have a mean mom. Okay? You know, she's always on, you can't do this, you can't do that. She's not a mean mama, she's a loving mom.
I didn't want to say stuff like that. It was, come outside, come hang out.
That's right. And your mama said, stay inside, don't hang out with them. You know, when I was growing up, they used to say, watch the company you keep.
I'm supposed to be in the house with my kids, and I'm
That's right.
out of my house and
That's right.
trouble.
That's right. So right now, you have children. You're a father. You're not a baby daddy. You're a father.
Yes, I very much am.
Okay. And so that's a first of all, you're blessed to be a father. And that's an awesome responsibility. Okay. And God has given you that responsibility to be father to your children. And so, like the old folks used to say, straighten up and fly right.
I'm trying to get it together.
Oh, you can't get it. You don't need to try. Just get it together.
I can say honestly, I'm trying a lot harder than I was.
That's right.
At first, when I had inquiries supposed to be coming to court, this, all that, nah, I'm not getting that.
Okay, so you mature. Okay, well, that's a good thing.
Being my kids for life, I stay with them.
That's
take
right.
care of them. I go to work, I go home.
But you know what? You see, those kids, when they looking for a roof over their head, clothes on their back, food on the table, they looking for you to get that to them. Why? Because that's your responsibility.
As I expect, sir.
Okay, they expect, and so you have the ability to do that. You just have to, like these folks say, you need to man up. Okay? You're not a little boy anymore. You're a man. And so you're gonna have to act as a man. When I was a child, I spake as a child, I understood as a child. But when I became a man, I put away my childish ways. Okay? You're not a child anymore. So all of those things that you used to do when you was a child, you need to put them away. Okay? Okay. So, but you can do it. If I can do it, you can do it. If any of us could do it, you can do it. Okay? You know, a lot of times people don't speak life into people. Okay, they just watch them go by the wayside. But that's what you need to do. You need to speak, you know, so that's what we're doing. We're trying to speak life into you so that you can be an example for your children. Okay? Because your children is what they see. What they see is what they'll be. Okay? They see you acting a fool, guess what? They gonna act a fool. Simple as that. Okay? But you can do it though. You can put this behind you. Are you working?
Yes, sir, I am.
Okay, that's good.
I'm actually working to get a second job right now.
Did you finish school?
No, sir, I'm going back to school so I can be able to get.
Okay, that's what you need to do now. There's a program, CICE, at Lamar University. They have a program, they have a GED program. You can get your GED, and it's a job training as well. You in the GED program?
I'm one, for the Texas workforce.
Good.
My 2 tests already. I will go and start my classes.
Okay, sound like you're on the right track. Okay. And Mom, thanks for coming down here with your son. You know, like I tell people, you know, hang on, don't hang up. Okay, just hang on to him. I know he's 22 now. You can't put nothing on his butt like you used to.
Excuse my language. She got 2 of my siblings yesterday at my house.
They probably needed it.
Yep.
Okay, but that's anyway.
Came to the window at Deer Queen.
Yeah. Yeah, but anyway, just continue on the road that you're on, okay? And just be patient with yourself, all right?
Yes.
All right, you're all right, all right? Just hang in there, hang on, don't hang up, right? And you have a blessed day.
Yes, sir. You.
All right, stand next to the bailiff.
Thank you, Judge.
Okay, you're welcome.
Judge, I like that, what they see is what they will be.
That's
I
true.
like that. Have a happy excuse.
Yes, you will. Yes, you are. You have a blessed day. Mr. Adams. We have Johnny Garcia. Mr. Garcia, why don't you come on up? Your attorney's on Zoom.
Hey, I'm here, Judge. I enjoyed listening to your words of inspiration.
Oh, okay. How
That
little
was
Langston
really
doing?
good. Oh, he's doing fantastic. Next month, he's taking off to La Ola.
Oh, that's good.
So he'll
Tell
be
him I'm proud of
gone.
him and tell him to keep up the good work.
I will. I'll make sure I tell him that. I definitely will.
Okay. Now, Mr. Garcia, how are you doing, Mr. Garcia? That's good. Now, Mr. Garcia, you're represented by your attorney Langston Adams. And Mr. Adams, what is your announcement in Mr. Garcia's case?
I need to put it on one more announcement. And the reason why is I got the written discovery, but however, I think that we're still waiting on the media from Miss Karen, I believe is her name.
Okay.
And once I get that, I can show that to Mr. Garcia, and then we can go from there.
Okay. Now, Mr. Garcia, your case will be reset for your attorney to get the video in your case. You can, this case is reset to August 12th. Stay in contact with your attorney and your bondsman. Once you get your reset, you're free to go and you have a blessed day.
All right, Judge. Thank you again. I enjoyed listening to you.
Okay, you're free to go and you have a blessed day.
All right, you too.
Your reset will be sent. Okay. And I think this will conclude the calling of the court's announcement docket, motion to revoke probation docket, both dockets on today's date, July 8th, 2026, in County Court Law number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day. Prosecutor, your excuse.